Good afternoon, everyone. Welcome back to our third series of Fair Housing Month, where we're celebrating April is Fair Housing Month. Today, I'm going to turn it over to Ann, who's going to introduce our speaker for today. And at this time, Ann, you can introduce our speaker for today.
Right. Well, thank you, Ashley, and welcome back, everyone on the call. Thanks for being with us. Today, joining us, we have Mr. Eric Dunn, who has been the Director of Litigation at the National Housing Law Project since 2018. The National Housing Law Project is a premier legal organization devoted to the rights and interests of low-income tenants and homeowners. As part of that work, he provides technical assistance to housing advocates nationwide. During the COVID pandemic, Eric led the Housing Justice Network response to the eviction threat, advocating for eviction moratoria and participating in legal actions to protect tenants' rights and uphold those moratoria and tenant protections. He is a national expert on tenants' rights and consumer law issues and known for high-impact advocacy on matters affecting subsidized housing tenants and families struggling to access housing because of criminal and eviction records, which is the subject of today's presentation. Prior to the National Housing Law Project, Eric was an attorney with the Virginia Poverty Law Center, the Northwest Justice Project in Seattle, and the Legal Aid and Defender Association in Detroit. One of Eric's most significant subsidized housing cases included Tina Hendricks versus Seattle Housing Authority and Shepherd versus Weldon Mediation Services Incorporated, which both led to significant improvements in the administrative hearing protections for families facing termination from federally subsidized housing. Relevant to today's presentation, one of Eric's most important victories includes Simmons versus TM Associates Management, which found that a landlord may have a duty to overlook a rental applicant's disability-related criminal conviction as a reasonable accommodation under the Fair Housing Act. We are delighted to have Mr. Eric Dunn with us today. Thanks for joining us, Eric.
Hmm. Thanks. So I'm just going to get right to the slides. Just want to start off. Um, I work for the National Housing Law Project. One of the things that we do is we administer something called the Housing Justice Network, which has we're up to more than 2,200 advocates nationwide, mostly legal aid housing attorneys, but also tenant organizers, academics who study housing issues, legislative advocates. We have a number of fair housing investigators and fair housing people, although not so many of those because I know that there's a separate fair housing listserv that most of them participate in. But if anyone's interested in joining our network, here's the sign-in information, and I'll also put it back up later uh, during the presentation. But with eviction records screening, um, as any of you who work on rental admissions issues likely already know, or any of you who've had to apply for an apartment in the last 15 or 20 years probably know as well. Eviction record screening is, very commonplace in the rental market. The data shows that about 85 to 90% of landlords use some form of eviction record screening. I think if you actually looked at the number of units, however, it's well over 99%. And that's because most of the landlords that don't do eviction record screening are going to be your small owners, sometimes called mom and pop landlords who might have, one or a couple of rental units and may not really do any kind of screening, but any of the bigger corporate multifamily properties are definitely going to be looking at this. And so, it's almost certain that somebody applying for an apartment is going to, be subjected to some kind of eviction record search and potentially be denied if they have any eviction records that would show up. So why do landlords look at eviction records? Well, of course, they're trying to figure out who's a good tenant, who's a bad tenant, who's going to be a good tenant, who's going to be a bad tenant, and they don't have a scale that you can step on tell you that. So they try to, make predictions about tenants based on uh, their performance in past housing opportunities. So that may or may not be a reliable approach, but that's what landlords do. And so one of the things they look at is eviction records. Do eviction records actually have any value in terms of predicting who's going to be a good tenant, who's not? There really is hardly any research on this. There's really only one study that really tries to determine whether eviction records have any kind of predictive value. And that study was conducted by TransUnion, which you may or may not be aware. TransUnion SmartMove is one of the largest tenant screening companies in the country, so they have a vested interest in showing the landlords that the information that they sell to them as part of screening reports actually has predictive value. So I think there's already a question as to how reliable that study could be, given who it comes from. But putting that aside, let's take a look at this study. Um, it was conducted in 2016, so about 10 years ago now. Um, they basically looked at people who moved out of about 200 properties, and they put them in two categories. Those people who moved out because they were evicted, and then everybody else. And then they looked at the people in those two categories and figured out how many of them had any kind of previous eviction record. And they found that of the people who were evicted, about 21.7% of them had some record of a prior eviction. It's not clear from the study what they considered to be an eviction record, um, but I think it's like judicial filings, basically. And then the people that were not evicted, only about 5.5% of them had prior eviction records. So TransUnion looked at this and they concluded that, oh, well, if you've been evicted before, you're four times more likely to default on your lease, on a new tenancy, which I don't know that the data necessarily supports that because we don't actually know like how many people belong to each category and so forth. And there's a couple other things you can notice about these numbers. One is that almost 80% of the people who were evicted from the new property were people that had never been evicted before. So there's a couple of different ways to look at this, but if we just sort of take TransUnion's analysis at face value, and we assume, okay, this would tend to show that there's some heightened risk if somebody has a past eviction record that they're going to default again in the future. Uh, what you notice is that TransUnion didn't do anything in this study to take into account the reason for the eviction. Now, this is one industry data point. I think this fluctuates maybe a little bit from state to state what these numbers actually look like, but far and away, the most common reason for eviction is non-payment of rent. So this industry study found about 77% of cases based on non-payment of rent. And of the remaining cases, most of them were things that weren't really any kind of tenant wrongdoing. It was something like the home being transitioned to some other use or possibly the owner's property being foreclosed. It was only about 9.5% of evictions have anything to do with a lease violation that other than non-payment of rent. And then even out of that 9.5%, you have evictions that, for example, would be somebody that falls behind in rent multiple times during the tenancy, and then the landlord decides they're not going to renew the lease. So even though the basis for the eviction may not be, technically non-payment of rent, you're behind by $2,000 and you need to pay or move out. It was still driven. The motivation behind it was failure to pay rent on time. So, the predominant reason that evictions happen is related to non-payment of rent. And so, how do we know that the TransUnion study wasn't just reflecting inability to pay? We don't, because they didn't do anything to control for the ability to pay. So, as far as we know, the 21.7% of those tenants facing eviction, we don't know whether they were in basically the same type of financial predicament that led to the previous eviction. They didn't have enough money to pay the rent and they got evicted, and now they're in that same situation again. Or whether there's actually any difference between people who are able to pay, where a past eviction shows that they still have some diminished likelihood of complying with the lease. So it appears to me that really what the TransUnion study is showing is that people who've been evicted in the past tend to be at risk of eviction for the inability to pay rent, and that may remain the case. They may still not have income sufficient to necessarily afford the housing that they're living in, and so they can be evicted over and over again. because they never get to a point where they're actually able to afford the housing that they're living in. That's different than if you were to actually compare people who have the ability to pay based on, you know, they've been evicted or not in the past, if they present a higher likelihood. So really the TransUnion study showing most likely that you have a higher likelihood to be evicted if you don't make enough money to pay the rent. And doesn't really tell us anything about whether eviction records on their own have any predictive value. So let's also just assume for, that let's say the TransUnion study did suggest that there's some predictive value. That if somebody has a past eviction, they're more likely to get evicted in the future, even if they have the ability to pay. How big is that? How big is that risk? Well, this is another TransUnion document which shows uh, they've created something they call a rental score or tenant score. And it's kind of like an SAT score where it's between like 300 and 800 or something. And the higher your score, the less likely you are to uh, be what they call a bad tenant. You uh, either got evicted or you moved out owing money. So according to their calculations, and this is based not only on eviction records, but also certain types of financial information that they work into their analysis, which is proprietary and we don't know exactly what they're looking at. But according to their algorithm, um, if you have a score above 720 on their scale, then you only have a 0.09% chance of defaulting on your lease. So that's infinitesimal, right? That's like 1 in 1,000 or no more. It's like 1 in 10,000 tenants is going to default on the lease. So it's not going to happen. It's infinitesimal risk. Well, if you're in the next highest score band, so you don't have 720 or higher, but you're in the next highest, you're between 780 and 719 on their scale. Then they've calculated that you have a 0.36% chance of defaulting on your lease. So again, two ways of looking at these numbers. One is, well, that's 4 times higher than somebody who has the best possible score. Right. So like, what landlord isn't going to want to favor somebody with a 720 or higher over somebody with a 680 to 719? Because, if you're in that second highest score band, your chances of defaulting go up, 4 times as high. But the other way is it's still a 0.36% chance of defaulting. You're still, 99 and 2/3% likely to comply with your lease. So I think most landlords, would you rent to somebody who has a 99 and 2/3% chance of complying with their lease? Probably would take that. It's still a vanishingly small percentage of people that would default on their lease. So really, how important is that difference between people in those two score bands? I would argue it's pretty insignificant. Well, if you even go to people that are in the lowest score band, have a score below 520 on the TransUnion scale, now you're talking about a pretty significant chance of default, right? They say 28.79%. And again, I don't know to what extent these numbers are even accurate or mean anything, but just assuming that they are. So that's about 3/4 of tenants in that lowest score band are going to still comply with their lease. So, one, I think good way to approach this type of data is, okay, well, we might not approve somebody who is in this lowest score band, but we should at least give them a chance to show why they're more likely to fall within the 3 out of 4 tenants who comply with their lease even despite having the lowest score, and they're not part of the 1 out of 4 who don't. So I think what this kind of information shows is even if something like an eviction record has predictive value in terms of how somebody is going to perform as a future tenant, that predictive value may be very insignificant. The industry will have you believe, oh, well, if they have an eviction record, then they're definitely going to trash the apartment and they're definitely not going to pay their rent and they're definitely going to get in fights with their neighbors. And the statistics really don't support, that kind of reasoning. It's, elevated statistical risk, but it's, certainly not a certainty. In fact, it's less than probable that somebody even with this kind of negative background information is going to default. And it's certainly not predictive of how one person is going to perform. And so that's really why it's critical that people have access to things like individualized reviews. before they're denied for background information like this. So some additional things to know about eviction records. One is that if you compare eviction record screening to other types of tenant screening you may be familiar with, especially take criminal history screening, for example. With criminal history screening, typically landlords are only permitted to look at criminal convictions where you have a court having adjudicated a case, and found the person guilty, whether they pleaded guilty or there was some kind of trial and they were convicted or whatever happened, there's been a judicial determination of guilt. But with eviction lawsuits, the large majority of eviction cases are settled. So you don't actually have the court deciding that, the tenant committed the alleged lease violation or anything of that nature. There's no judicial adjudication of fault on the part of the tenant. And then most of the judgments that do occur in eviction cases, or at least a high percentage, are by default. So you may have, a landlord files an eviction case, the tenant decides, yeah, I could defend myself, but it's not worth it. I'm just going to move out. The tenant doesn't really have any motive to show up and defend anymore because they're moving out. The court just enters a default judgment because the tenant didn't go to court. So even though there's a judgment, it doesn't necessarily provide any real insight into whether the tenant actually did what they were accused of. And that's really the case even when you have actual cases that are actually litigated to a result, because a lot of times civil cases, the judges tend to be pragmatic and resolve the case, and there's not always a clear winner or loser. So this is from a real case that's sort of modified. It's simplified, and of course the names and so forth are changed. But it's one where you had a landlord sends a letter to the tenant to raise the rent by $100 a month, beginning the following month. Again, these are not the correct dates, but the tenant was in the middle of a term lease, so the lease hadn't expired yet, and the rent was fixed by the lease. So the landlord didn't really have the right to raise the rent at that point in time. So the tenant calls the landlord back and says, I shouldn't have to pay this. I've still got my 12-month lease. And the landlord says, if you don't pay, then I'm going to take you to court for eviction. And the tenant responds by just not paying the rent at all. So instead of not just paying the $100 increase, the tenant just doesn't even tender any rent money at all. So the following month, the landlord provides a eviction notice to the tenant saying, you've got to pay this money plus a late fee, or move out within so many days. The tenant doesn't pay, doesn't move out. So the landlord files the eviction lawsuit, and there's a court hearing, and then the judge enters a judgment for the landlord, but for just the original $1,500. So the judge denies the rent increase, doesn't even allow the late fee. And under the law of that state, the tenant had up to 7 days in which to pay off that judgment, and then we'd be able to continue the tenancy. So who prevailed in that case? If you just look superficially, well, you see the landlord got a judgment, $1,500 against the tenant. Sounds like the landlord won. But if you look more closely, it's like, well, what was really the dispute about? It was whether the tenant had to pay this $100 rent increase. And the court clearly ruled that no, the tenant didn't have to pay that. And the tenant, didn't really lose their housing, because as long as they pay the amount of the judgment, which is the same as what the original rent was, the tenancy continues. So, an issue with these cases, even when there's a judgment, a lot of times you have to really know more information and to be able to interpret it correctly and know, who really prevailed in the case. And a lot of times that's not possible, because that's not how these tenant screening systems function. This slide's a little out of sequence, but we'll see there's a lot of misinformation, incorrect information in tenant screening reports. But whether the information is true or not, what we actually see is landlords using a lot of automated systems and these algorithmic decision models, where it doesn't matter what actually happened, doesn't matter like who actually won the case, because these systems are just designed to be fast and efficient, and the accuracy of the outcomes and fairness is not really part of what they're designed for. So landlords want to just have a computer figure out who meets the criteria, who doesn't, render a decision. They don't want to have to train anybody to interpret records or get the records in the first place, because that takes time, and they have to train people and that costs money. So landlords prefer to avoid that and just have these automated processes that often lead to unfair and unjust results. I should say, even though probably the most common way that landlords handle eviction records is just to automatically decline anyone who has a record of a case being filed against them. Uh, we do see a lot of other landlords that have policies that are less restrictive than that, but they are still highly restrictive. So, for example, they may only ignore an eviction if it's actually been dismissed, or they may impose, say, a 5-year look back period for eviction records instead of the effective 7-year limit that the Fair Credit Reporting Act imposes. So it's not as long, it's not as long as it could be, but it's still, pretty, 5 years is still a pretty long time. Um, sometimes they will have different kinds of procedures where if you're denied admission for an eviction record, you can appeal that, or denied admission for any reason, you can appeal that. But then when you look more closely, really all it is if you can get the information deleted from your screening report, then they'll reconsider the application, but they're really not interested in hearing information about new jobs or mitigating circumstances or anything like that. So of course the most restrictive policies are these automatic, you're automatically declined if you have any kind of eviction record that shows up. But even a lot of the policies that are less restrictive than that are still pretty difficult for people to obtain housing with these kinds of records. And this is just to give an example of how some of these policies manifest, like how tenants experience these types of policies. So this is from a case that's currently pending in Chicago, where in order to apply for housing at Hunter Properties, they will only accept an online application. So you can't go into the office and do like a paper application or anything like that. You've got to do the online computer application. And when you go to the website to do that, the first thing you're going to see is this little paragraph of information where they tell you that prior eviction filings will result in denial. So, it's not may result in denial. It's not could result in denial. It's will result in denial. So if you have a prior eviction filing, you're going to be denied. And it's filings. It's not judgments or findings of culpability or anything less than that. It's filing. So even if the case was filed against you and you won, you're still going to be denied, no exceptions. So I think a lot of people that, might, even if they won their eviction case, would probably be deterred from filling out this application because it says you have no chance. It doesn't matter if you won your case, it's a filing. Add to the fact that you've got to pay $70 per adult household member to submit this application. So it's one thing if you have an eviction record, but maybe it's not a judgment, or maybe you paid it off, or maybe it's a judgment, but there's mitigating circumstances, or maybe it's just a long time ago, or whatever. You might submit the application anyway and see if you can appeal or something, but now you've got to pay $70 to submit that. Well, now you're even more likely to decide, what, I'm not going to bother. And they also say that any kind of false or misleading statements will also result in denial. So, what if you got an eviction notice from your landlord and then you moved out and you later saw that there was a case filed in court, but as far as you're concerned, that that wasn't proper, and you might say no, and then you're going to explain later, well, that might be considered false or misleading. So they really make it clear to people that they're not looking to rent anybody with any kind of eviction record, and most people will probably not even bother to fill out the form. But if you do try to fill out the form, the first one of the questions that you must answer. So there's this asterisk on the web form, which we're all familiar. If question has an asterisk, you need to answer that question, or the computer is not going to accept that form until you fill in one of those bubbles. And they ask, have you ever been evicted? Yes or no? But do they tell you what being evicted actually means? Because like I was a legal aid lawyer for 16 years, and people's idea of what being evicted means is all over the map. Like some people think it means the sheriff comes to your house and physically hauls you out of the property and then sets out all your personal belongings on the sidewalk, and that's being evicted. And anything less than that is not being evicted. There's other people that think if my landlord calls me on the phone and tells me I need to get out, that's being evicted. And everything in between. So if the landlord gives you an eviction notice and you move out on your own, is that being evicted? If a landlord files a case against you in court, but you win, is that evicted? If you have a court enter an eviction judgment against you and say you've got, 3 days to get out of the property, and then you leave before the 3 days are up and the sheriff never comes, is that being evicted? I mean, they don't say, they don't specify. So, very easy that people could, maybe not understand what this question is, but false or misleading statements will lead to a denial. If you got an eviction notice and you don't consider that alone to be being evicted, but if the company does, then you're out your $70 and you're denied for a false statement. So people are kind of incentivized to just treat anything that could be an eviction record as a yes. And of course, if you answer yes, then you're denied. So a lot of deterrence on this, to deter people that even have anything approaching an eviction record from applying. And this property also says that you have to disclose the name and address of a current landlord and provide their email address. So even if you have, like, say, an eviction record that was sealed, or you negotiated something out of court and there was never actually a judicial record, but the landlord was in some kind of process to try to remove you, they might even find out about that. So I think what this really shows is that you may find properties that might have really low rates of actually rejecting people for eviction records, but it's because there's so many people that just never even submit applications in the first place because they're deterred by these kinds of statements and electronic procedures. Now, you might be thinking, geez, if I'm a landlord, don't I want to rent my properties? Why would I want to be denying people and deterring people from applying? Isn't that against my financial interests? I mean, I'm trying to make money renting properties, and here I'm like, excluding all these people. Well, I think there's a few reasons why landlords do this anyway. The first is, kind of as I alluded to earlier, it's just easier to have rental admission processes that are just automatic and electronic, and you don't have to train anybody. You don't have to worry about interpreting records and so forth. So it's just cheaper and faster and easier. And if that means that certain people don't get housing, that's not your problem. So unfortunately, I think that's, probably one of the big drivers of these eviction record policies. I think related to that is, we have a housing crisis. I mean, we have more than 700,000 people homeless on a given night in the U.S. There's more tenants that need housing than we have housing available and affordable to the people that need it. And so landlords know that if they turn down somebody who's, would be a perfectly good tenant, oh, well, we'll just have somebody along later in the afternoon who we can rent to. So the market isn't really punishing these kinds of overly restrictive eviction history policies. And then I think another reason that, sometimes you might hear landlords come out and say this behind closed doors, but, they don't come out and say this publicly, but it's that if landlords are generally denying anyone with any kind of an eviction record, or making very limited exceptions to very few people, that means that tenants are going to be awfully reluctant to do anything they might think would cause a landlord to file an eviction case against them, whether it's deserved or warranted or not. So if you've got a repair problem and the landlord's not fixing it, are you going to call code enforcement? Well, I mean, they might file an eviction lawsuit and it can be dismissed for retaliation, but you still have an eviction record, and now good luck renting anywhere else. Do you really want to stay in that apartment long term with that landlord? Often not. We saw the earlier example where the landlord tries to do an illegal rent increase in violation of the tenant's lease. And the tenant objects to it, and the landlord says, well, if you don't pay, then I'm going to bring an eviction case. And if you understand that, having that case filed against you is going to impair your access to housing in the future, you may be better off just paying that increased rent, even though you don't really owe it, than objecting to that and risk acquiring an eviction record. So I think just chilling tenants from being able to exercise their rights, um, and really have any kind of fair uh, opportunity to defend themselves and get full relief in eviction court, I think is another significant reason why we see these kinds of policies. Now, I mentioned ease of administration. The landlords like to have these types of black and white. If you have an eviction record, you're out. If you don't, you may be in type rules. And this is kind of why. If you're not familiar with tenant screening reports and where the information comes from, I mean, they have these computer systems that are networked with all manner of different public and private databases and information systems. And at the push of a button, these tenant screening algorithms will pull up this information, basically instantaneously from all these different networked databases and compile it into a report on a person. And then they will apply a filter. Looks kind of like this. I mean, there's different versions. This is one company's filter, where landlords are given these, pull down menus or electronic check boxes, or sometimes they'll be given a paper form to fill out that has this information. But basically, the landlord is putting in a set of standard rental criteria, and then the automated system is going to machine read the data that comes back, and then try to apply these criteria. You may not be able to read it, but in the middle of the page, you'll see, one is no landlord tenant court records or unpaid collections. Any number ever is pass fail. So that basically is an electronic, code way of saying if you have any landlord tenant court records ever, then you fail. You're denied. Now they did check a box on this one for ignored, dismissed, or satisfied records. So if the case was dismissed or if you paid off a judgment, then it will ignore that one. So this is not, one of the most restrictive, policies that we've seen by any stretch. But a lot of landlords will not check that box, and then it's automatic exclusion. And again, it's any number, so it just has to be one record ever, and it doesn't. There's nothing in there to, where okay, it was a judgment, but it was for less than the full amount because the tenant was properly objecting to a rent increase or something. That it just doesn't have the ability to process those types of nuances. And then once these algorithms run the filter, then it generally creates some kind of score, or sometimes just a thumbs up, thumbs down, green flag, red flag type of recommendation, accept or decline. And what the screening companies say, and the landlords a lot of times, they love this. They're like, oh, we don't have to worry about interpreting any information. We don't have to worry about applying complicated rules. We don't have to train anybody. And we just get a yes or no. The computer decides, and we don't have to put any further thought into it. And so it's cheaper, faster, and that's why landlords like it. Now, of course, one of the big problems with this whole process is that the use of eviction records, and especially with these sort of automatic decline policies, is that it has a disparate impact on Black renters. This is a chart that was prepared by the Eviction Lab, just showing, on a nationwide basis, what this impact is. You'll see that they group renters into 4 racial groups: Asian Americans, Blacks, Latinx, and white. And Black renters are the only racial group where they're overrepresented among eviction defendants, compared with their proportion of the rental market. So that means that, basically, Blacks are a little bit less than 20% of renters nationwide, but they're well over 30% of eviction defendants. So they're disproportionately sued for eviction. This is especially true of Black women. It's estimated that about 1 in 5 Black women will face an eviction at some point during their lifetime, and that's about 3 times higher than for white women. And there have been studies on this in local communities all over, well, not all over the country, but in a lot of different communities, and we just see over and over again it's the same pattern that Black tenants, and especially Black female tenants, face eviction at dramatically higher rates than any other group. This one that I have on the screen now is from King County, Washington. You'll see these, a couple of tall bars that stick out. I mean, these are for Black tenants. And then the very highest one is for Black female tenants, more than 6% eviction rate in King County compared with, 1% eviction rate basically across, for the general population of renters. Um, for Black men, it's about 4%. So, um, Black tenants, especially Black female tenants, we can consistently see this pattern facing eviction at substantially higher rates. So when we have a policy that has a disproportionate negative effect on protected class, then of course, we're usually thinking that that's probably something that may be subject to a disparate impact type analysis. Um, and so, if we've got a disparate impact on Black renters, well, we have to look at, does that policy serve a substantial legitimate purpose? And even if it does, is there a less discriminatory alternative? Well, as I think we saw before, it's debatable whether there's really any evidence of a predictive value for landlords in using eviction records. I mean, there may be some, but even if there is, it's very attenuated and pretty minimal. But even if that's a substantial legitimate justification, which is questionable, is there a less discriminatory alternative? And certainly there's the option of doing individualized assessments, and instead of just automatically declining people with eviction records, using that as sort of a first pass, and then providing an opportunity to provide mitigating evidence, change circumstances, and so forth. So pretty solid disparate impact claim to challenge landlords that have these types of policies. Now I know, especially in Mississippi and the Fifth Circuit, disparate impact, not really clear how viable it remains. Of course, we had the 2015 decision in Inclusive Communities Project versus Texas Department of Housing and Community Affairs, which the Supreme Court basically agreed with all the prior federal appellate courts that yes, the Fair Housing Act is enforceable through disparate impact. But I know in the Fifth Circuit, you since had the Lincoln Properties case where the court just made such a outrageous misinterpretation of how you apply the statistical analysis that if courts continue to do it that way, it basically makes it impossible to prove the first prong, the disparate impact prong. So I haven't really kept up with how disparate impact continues to be applied or misapplied in the Fifth Circuit. But at the end of the day, it's a solid theory. Just whether the courts will actually do their jobs correctly, I can't say. Now, apart from just the whether the courts and the judges are deciding cases according to facts and logic or political ideology, there are some other impediments to bringing disparate impact cases. Probably the big one is that unlike say criminal history data, eviction data can be really hard to come by, and you may not be able to get it at local enough level to run the kinds of statistical impact analyses that you need to support disparate impact claims. So that can be a real challenge. And then of course, even if you have access to the data, you need somebody to crunch the numbers and run the analysis, and the experts can cost a lot of money. So there are a lot of impediments to being able to bring these types of cases, but it's been done before, and there are some additional cases pending currently. So this is a list of the 4 that I'm aware of. Just disclaimer: I've been personally involved in 3 of these, but there's at least one case that survived a motion to dismiss already. There's another one pending a motion to dismiss in Chicago currently. So the legal theory has already been approved by accepted by one court. That was the one in Jacksonville. Hopefully we'll be able to add another court to that list very soon. I mentioned individualized assessments. This is probably a term that people working on fair housing are familiar with from the criminal history context, but HUD put out guidance in 2022 basically on eviction records saying, if you're going to deny somebody for eviction history, you need to do kind of the same thing that they recommended at the time for criminal history. You need to look at, well, how recent was this record, and is it relevant to the person's current circumstances? And was there any mitigating information related to that eviction? You can't just use these blanket policies of no eviction records whatsoever, and expect those to hold up against a disparate impact challenge. So that guidance has since been withdrawn for whatever reasons. Uh, HUD's withdrawn pretty much every guidance that's been issued, for the last, 20, 30 years, since the new administration came in, really without explanation. So it may still have some persuasive value, but they haven't issued anything to replace it. Mentioned earlier that another impediment to people applying for these properties can be the rental application fees. It just raises the stakes on people that if you're going to apply for this housing and you don't get in, then you're out this money that you might need, to get in somewhere else or to pay the first month's rent and so forth. There's even some data suggesting that simply charging rental application fees may in and of itself be discriminatory. Zillow reported a couple of years ago that according to their information, white and Asian American renters, Black and Latinx renters are about twice as likely as white and Asian American to have to submit more than 5 rental applications. So these are people that are being denied over and over again, keep incurring these fees, and that's likely to have real impacts in terms of where they choose to apply. And over large populations, steers more Black and Latinx tenants to certain neighborhoods and away from others. And so you can imagine the sort of segregative effects that sort of practice would have. So, I think the rental application fees are certainly potentially discriminatory on their own, but they also have a real impact in terms of, whether people are actually applying to properties and being formally denied, whether it's for eviction records or other things, as well as, where they're choosing to apply. So, what are some things that can be done to push back against the harmful impacts of eviction record screening policies? In a lot of different parts of the country, we've seen efforts to establish eviction record sealing laws. These take a number of different forms. The basic idea is that it creates procedures for which the court can basically seal public access to eviction records so that the defendant's name doesn't show up in tenant screening databases. One thing people say, well, once the case is filed and then the information's out there in the public, you can't put the genie back in the bottle. Not really true, because we have the Fair Housing Act. And so even if the information gets out into the public realm and winds up in some of these databases, the Fair Credit Reporting Act requires those databases to be updated every so often. And there are dispute procedures you can use to, basically get your name taken back out of that if they can't verify the information. So, these laws tend to be fairly useful for the people that are able to take advantage of them. The problem is that most of these laws, have pretty high standards for being able to, seal your record. A lot of them are like, you have to show the case was filed without basis in law and fact, or, basically bad faith on the part of the landlord. So, very few of these laws would enable you to seal something where, the tenant actually did fall behind in rent. And then maybe they negotiated a move out agreement or something. I don't necessarily feel like these are, the be all end all. But when they are available to people, that they can be the most protective, because if you can just erase that record from the public domain, then landlord can't deny you for something that they can't find out about. So, a lot of states have a specific procedure now that you can follow to ask the court to seal the record, even if they don't. Just about every state, if not every state, has a general record sealing rule or procedure that you can use. You may be able to seek an order to seal an eviction record under a procedure like that. Another set of reforms that we've seen, scattered places, have more to do with just creating procedures that make it easier to challenge a denial, or things like just requiring the landlord to actually give you a reason why you were denied, put that reason in writing. So you get your screening report back and maybe you have an eviction record, but you've also got a misdemeanor arrest and you've got a bad, you've got a collection account or something. And if you say, well, landlord improperly denied me for this eviction record, even though I won the case. Oh, no, it was because you have the criminal record. It was because of the debt. So, forcing them to actually, put down a reason so they can't just move the goalposts, can help with these sort of things. Having any kind of formal appeal or reconsideration procedure, and then certainly, putting restrictions on rental application fees so that, people can actually apply for the housing without, being out money if they don't get in, um, can facilitate some of these things. And then, certainly putting any kind of substantive limits on, what eviction records landlords can deny for, um, has the greatest impact. We've only seen this in a handful of jurisdictions. New York and Oregon have some laws in this area, but whether that's shortening the look back period. So under the Fair Credit Reporting Act, there's effectively a 7-year look back period for eviction records. It's illegal to report civil suits more than 7 years after the date of the record. So effectively, a landlord could still look up the information on their own, but since almost all of them rely on these tenant screening reports, it wouldn't be lawful for the screening company to report that. But a state could shorten that, effectively prohibit denials based on eviction records for more than 4 years or 3 years or some shorter period of time. Still doesn't help the people, within that look back period, but at least, reduces the level of harm. And then we've also seen a number of states and jurisdictions enact laws prohibiting the use of certain egregiously unfair types of eviction records. So a couple are eviction records filed against people based on reasons related to domestic violence, eviction cases filed against people who were basically tenants renting the property when the landlord got foreclosed. So in a lot of jurisdictions, there's not even any notice requirement. So the bank purchases the property at the foreclosure sale, and then they can just file a case in court without even notifying the tenants that the property's been foreclosed or anything like that. So those are particularly unfair to the tenants when they acquire those records. There have been a number of situations where landlords have named minor children in eviction complaints, either because they didn't know any better or because they thought they had to name every single person in the household in order to get a judgment. And so you have somebody who's 15 years old and they get sued in eviction court because their parents don't pay the rent. And then 4 years later, they're in college and they can't get an apartment because, when they were a teenager, they got sued for eviction for, property they weren't even, the leaseholder on. They were an adolescent. So there have been a number of these types of laws. So anything of that nature can, really reduce the incidence of these types of records. But I will say the main people who are, problems here are people that, they didn't pay the rent. They got sued for eviction, but, things have changed and they could pay the rent now. So it's really a huge public policy issue for those folks who, they're struggling to obtain housing. And just working with tenants who are in this situation, they have an eviction record, they need to get housing. What are some things that can be done to improve their opportunities? And first of all, to the extent you can do anything to remove negative information from their screening report, it's kind of obvious, but you want to do that. But a couple of points. And one is, just because somebody's applying for housing in one community today, they may have an eviction record from somewhere else in the past. So even if you don't have any kind of record sealing procedures for evictions in your community, that doesn't necessarily mean that nothing's available to that person, because they may have acquired an eviction record in a different state or a different county that has some procedure that's available. So that's the first thing to look at. And then, pretty much any kind of rental admission advocacy that you do, you're probably going to want to have that person request a copy of their tenant screening report and just look it over and dispute anything that's improper. So it's easier to get housing if you've got an eviction record only than if you've got an eviction record and a criminal record and negative credit information and so forth. So those are going to be kind of the first steps. Since you can anticipate the person being denied admission, you want to, you want that person to have, something to say if you need to send a letter or go to some kind of appeal procedure. So, try to marshal, whatever evidence you can of that. So if they've got new employment, if they've got a housing voucher, if there were, the eviction was filed when the person was in their mid-20s and they had roommates and the roommate did something and the whole everybody got evicted and they have an eviction record because of something somebody else did, and that person's not going to be joining the new household, whatever it is, try to, have that evidence ready. And then, usually it's going to be necessary to do a formal application at a property. So, it's important to, be strategic about, where that person applies, because they're probably not going to be able to just apply all over town due to the application fees. So, they should look at a property, that they definitely want to live in, that they definitely have the means to afford, and make sure to document any kind of communications with that property, any kind of rental advertisements they look at, policies or documents that they're given. Because if you could find any kind of, like, just little legal picadillos that the property doesn't comply with and so forth, it gives you leverage. It gives you an opening to talk with them and try to get them to reconsider applications. Kind of one exception to that is if you have somebody that reaches out to the property and they are specifically told, we will not rent to you because of your eviction record. Sometimes it can be better to just go with that rather than have them do a formal application, because then other negative things could come up, and again, it creates this opportunity for them to move the goalposts. And then if they're denied, you want to aggressively, contact that property and get, ask them to reconsider the application, present evidence of changed circumstances or whatever you've got. And ultimately, if the property won't do it, then, that's when you would look at, are there legal claims that we can assert? But that's, really all I had in terms of slides. I think I might be a little bit ahead of when I was expected to wrap up, but I wanted to put the information for the Housing Justice Network back up on the screen in case anybody is interested in that, and I didn't get it before, but I will be happy to answer questions anyone has. I apologize that I haven't been able to monitor the chat as I've been speaking, so if there's anything in there already, I could certainly look at that, but if folks have questions now, I can take them.
Thank you so much, Eric. As of right
there's
now,
one question.
yes, and they're asking, will they be able to get a copy of the presentation?
Yeah, absolutely. I think I already sent it to Ashley, and you're free to forward that, or I can send it, but
Okay,
it might
I
be
can make sure
that way.
I send it out. Okay, I will make sure that I send the presentation out to everyone in attendance. Do we have any questions? Anyone? Either you can type the question into the chat, or if you raise your hand, we can give you the permission to ask your question live.
And I'll start us off. Eric, if you don't mind, you talked about individualized determinations as an alternative to these electronic screening approaches. What might a individualized determination by a housing provider look like?
Okay, so if you go all the way back to, like, say 1975, there was a case called Missouri versus Green versus Missouri Pacific Railroad. And this was an employment case where the railroad company had a policy basically that they weren't going to hire anybody who had any kind of criminal history whatsoever other than like a minor traffic offense. And, because this was shown to statistically exclude far more African Americans from employment with that railroad company than members of other racial groups, we had a disparate impact. And so the company was asked to justify that. They couldn't. And, so basically they violated Title VII, employment discrimination law. And the reasoning was, look, if you want to screen people for criminal history, that's fine, but you can't deny somebody for any kind of criminal history they ever, acquired, no matter what the circumstances, no matter how old it is, whether there's evidence of rehabilitation, whatsoever, that cannot be justified by any kind of business necessity that the railroad would have. So if you're going to screen people for criminal history, you need to look at the individual circumstances and make a decision, based on that one person, and not just, have these blanket bans. And that was like back in the mid 1970s. And so HUD eventually in 2016 adopted that as uh, the basic standard for looking at criminal history in rental housing admissions. That you have to do an individualized assessment. Look at things like, well, what is the criminal record? How does it relate to housing? How old is it? How many years ago did this take place? Is there any evidence of mitigating circumstances and so forth? Do you actually have any evidence that this crime predicts that this criminal record predicts that they'll do something dangerous in the future, that sort of thing. And so, uh, then, as I had one slide on, HUD basically took a version of this in 2024 and promulgated. Well, it was actually sub-regulatory guidance. It wasn't promulgated; it was just published. But applying the same thing to the eviction record context is okay. Well, yeah, you can look at eviction records, landlord, but you got to take an individualized assessment of when was the eviction, how long ago, and what were the circumstances, what was even the outcome of the case? Did the tenant win? Like, why would you be using that against them? Um, Even if they were genuinely evicted, I mean, what was it for? Was it for non-payment of rent? Okay, well then, is there evidence that they can afford the rent this time, et cetera? So it's looking at just the totality of circumstances around an individual person rather than just having these, one size fits all automatic policies that cause disparate impacts. And if you've got the eviction record, you just don't get the housing and tough. Um, so it has a long history, uh, you know, back to the 1970s. And this has been basically required under judicial interpretation, even though it's fairly recent in terms of the regulatory policies around this.
Thanks so much. And not seeing any questions from our audience, I'll indulge myself with one more quick one, if you don't mind. You talked about the Fair Credit Reporting Act and how that gives us a 7-year look back restriction on civil cases, including evictions. Could you talk about whether there's any such law on criminal records, whether housing providers can go back and look at criminal records of a certain age? We do expungements at MCJ in part, I think, for housing reasons. But are there any laws that restrict how far back they can go?
So the same provision of the Fair Credit Reporting Act, it's I can write the citation in the chat. It's uh, it it has a number of different contents. I know it's civil suits and judgments and records of arrest. There's some other things in there, I believe, but those are the two that I'm most familiar with. And it basically says consumer reporting agency. So that's any kind of company that gathers and compiles and sells consumer data for the purpose of consumer related decisions. So that's, of course, there's the big three, Experian, Equifax, and TransUnion that do financial credit reports. But it also includes anybody that does any kind of background check. So like, tenant screening companies, of course, employment screeners, uh, people that do background checks on people applying for different kinds of licenses and, checking accounts and all that type of stuff. They're all considered CRAs, or consumer reporting agencies. If you are a CRA, then the statute says it's unlawful for you to report civil suits and judgments, records of arrest, certain other information that antedates the report by more than 7 years. So that means that if you have a record of arrest, and it's more than 7 years old, Consumer Reporting Agency is prohibited from reporting it. Now, it does not put any limit on adult criminal convictions. So if it's just an arrest record, that provision applies. But if a person was convicted, it doesn't. Now HUD had basically in its own guidance regarding the Fair Housing Act had said, well, if you're going to be denying people housing for criminal records, you should only be using convictions anyway. So I think there's also a fair housing claim, regardless of whether it's beyond the 7-year look back or not. If it's just an arrest record, if it's a conviction record, then there may be fair housing considerations, but the Fair Credit Reporting Act doesn't limit the reporting of convictions.
Do we have any other questions? I'm not seeing any, Eric.
Okay, well, I mean, I don't really have anything else to say. If we want to end, is it 15 minutes
Yes,
early or whatever? I mean, that's fine with me, but I mean, it's up
that's
to you.
great.
However you.
Yes, we can definitely end. You have some people in the chat that is saying thank you so much. And I would again like to say thank you. Was able to learn a lot today in regards to eviction screening records and the Fair Housing Act. So thank you again, Eric. And for the attendees on the Zoom, we will send out his presentation that he went over today. So thank you all for joining. This is a reminder that we will resume next Thursday, same time, same length, and we will talk about disability rights under the Fair Housing Act in regards to reasonable accommodations and modifications. We hope that you guys will be able to join next week, and thank you again so much, Eric. Okay. Have a good rest of your day, everyone. Bye.